All right, well, welcome back. Today is Tuesday, and it is March the 3rd, 2020. As always, it was once again a very busy day. I know I say that a lot, but that is exactly what's going on. So today we had an informed consent bill, kind of masked as an abortion bill, as well as a new red flag. So let's jump right into that first topic. So it was HB 364. It was actually heard on Friday for roughly about an hour. During that time frame, there was quite a bit of questioning that came up. They actually ran out of time, and so they held it in committee and heard it today. It's kind of been making its way through the news, and KSL and other places have been picking up on it. We've got the link down below. It's run by Steve Christiansen, and the Senate sponsor is Curt Bramble. So the bill sponsor was very, very adamant in stating over and over that this is an informed consent bill. And he also wanted to make very clear that the best information leads to the best decision. And further stated that in the end, it is still the woman's decision. So looking over the committee hearing on Friday, I wanted to read some of that so that we as listeners can understand why it's so important to choose just exactly how we're going to argue particular discussions and where we're going to go with those, and look those over. So a couple very interesting interactions occurred between two Democrats and a representative that was running this. And the first came from Representative Wheatley. And so he's from Murray. He is an administrator at the Salt Lake Community College. Been up there since 2005. So he came in hot and heavy, and he initially wanted to say, who decides what is the best information, the doctor or the government? And Steve's response, he looked around and he came up with a pretty good one when he said, when information becomes relevant and real, the quality of info is the best. He cited some of the stuff from the Kentucky bill, and Wheatley just wouldn't let him go. He kept asking him, who decides what is the best information? And Steve says, well, I'm sponsoring this bill, so I think the government, obviously, right? Representative King then came out at a little bit different one. He wanted to understand the difference of the types of ultrasound, the transabdominal, which is obviously on the outside of the woman, or the transvaginal, which is inserted into the vaginal cavity in order to perform the ultrasound. The interesting thing here is that the transvaginal is one that will pick up heart rate, will show, especially for a young developing fetus, 4, 5, 6 weeks of age. The transabdominal, most of us know and understand, that one's going to be a little bit more tricky, especially with a younger fetus. And so Representative King then said, is there any medical necessity for this bill? And Steve says, yeah, the potential risks, yes. And he says, well, have you consulted with medical experts to see if the bill lines up with the generally accepted medical standards? Now, why is it that Representative King got away with this particular line of questioning, which is relevant, right? The reason he got away with it is because the representative had chosen to make this about a medical procedure and informed consent, not about life, not about death, but instead informed consent. So he says, all right, I'm going to be very interested to see what the Utah Medical Association has to say. And he says, are there any other medical procedures where we mandate unwilling medical provider carry out? And Steve says, well, I don't know. And he says, is there any other medical procedure that we mandate occur on an unwilling patient? And, so Steve talked through that and says, well, the ultrasound is administered, and it's, you could say no, you could say yes. And so King just says, so the answer is no. There is no medical procedure that we mandate occur on an unwilling patient. And Steve says, well, I don't know. Well, I'm thinking back to the birth of my children, right? I've got 5 kids. And the state of Utah does mandate a test called the PKU. Whether you want it or not, you can't say no to that. There are also a number of treatments that we do perform on minors. And so in the event of that individual presenting themselves in a certain way, we will mandate a variety of different tests. But anyways, I wanted to highlight that for the simple fact of making sure that we understand, once you kind of let the boat sail away on a particular line of thought or discussion, you're really opening yourself up to everything that's going to get hit there. And the bill barely passed. So today, it actually came through 6-5. One Republican jumped over. Let's look up to tomorrow, though. So tomorrow in committee, we actually have a bill that is very exciting that's coming out. We want to make sure we look at, and it is at 8 a.m., so just a few hours from now, and it's HB 241. These are the kindergarten attendance amendments. We've done a show on that before, but here it is. It's finally going to come to committee. So it's lines 131 through 134 that we really want to pay attention to, and it states, if the student who is excused to attend a home school under this subsection is excused from kindergarten, the local school board shall provide a kindergarten syllabus or otherwise identify the knowledge, skill, and competency as a student is recommended to attain. So that means that if you choose to keep your child in your home just for kindergarten or long-term, whatever the case may be, that they can actually come in and try to identify knowledge, skills, and competencies. Again, invasion of privacy, invasion of parental rights, invasion of the student. And again, we're talking about children at or around 5 and 6 years old. But moving along, we also heard 26 bills today. There were 6 opposed. 4 of those had more than 10 votes. So let's look at those. We had a concurrent resolution 22, and that was the protection, development, and beneficial use of Utah's Colorado River. 57-13. A lot of the reason why people were opposing this is they just thought, we've already got good information. We have other departments that are doing this. Do we really need to be doing it twice? We also had HB 62, an enterprise zone tax credit amendments. Interesting, this was trying to take hydrogen fuel tax and extend that incentive. Now, it's like the legislators set up there that is that really the role of government? In my opinion, no, it is not. As new things come to market, should the government be the one that is infusing cash and infusing rebates to really contrive the public to make a decision? In my opinion, no, they shouldn't. But in this one, 44 said, yeah, they should. 23, no, they shouldn't. HB 328 was the Division of Water Resource Study update, and this was to update a 2002 study of the Green River. Again, 23 people didn't like that one. We also had HB 349. Now go back to the principle of equal protection under the law. And what this is it was insurance modifications. What does that mean? It meant, and it means, that a living organ donor, meaning you're going to donate a variety of your organs to help someone else, maybe a part of your liver, maybe a kidney. The list goes on and on in today's world. This was going to say if you are a living organ donor, that it would prohibit an insurer from discriminating against you as relates to insuring you. Again, equal protection under the law. If someone is putting themselves in harm's way, which any medical procedure does carry a risk, shouldn't the insurer be able to determine what that risk is? But here's government trying to step in and say no. Again, 23 people said no. HB 317 was the no road engine study. Very interesting thing here, because we finally found out from Representative Snyder what in the world a no road engine is. It's not simply big commercial farm equipment, things of that nature. It's also, guess what? Your lawnmower, string trimmer, all sorts of small motors that you would have to divulge what you have, how often you use them, what an invasion of privacy that the government is causing with this. It was only a $50K note. It flew through committee. A number of those that saw it come through committee, kind of shame on you, should have done a better job investigating the bill, but they did say no when it came through today. So it was one of the few bills that actually failed. On top of that, we also have some new bills coming out. We had 23 new ones, 2 of which I think we need to touch on. One was SB 229. Now, this is an administrative rules amendment that Jacob Andreg's bringing us, the man who knows no limits on legislation. This bad boy, 5,118 lines. It's really lines 13 through 20 that give you a high-level view of this bill, and it is going to create a director position within the Office of Administrative Rules to define the duties of the director. So really, we're trying to say, part-time legislature, let's make sure that the Office of Administrative Rules, that's going to now be, if this bill passes, a full-time position with thousands of lines of new code for what they will be doing. Very dangerous bill. I put it in the title. I apologize for waiting this long to talk about it, but HB 460 came out. This is a red flag bill. It is firearms removal amendment. The link is below. It says this right in the bill. Enables a family member, medical professional, or law enforcement officer to ask a court to restrain a person from possessing any firearms or ammunition for a specific length of time. Again, Innocent until proven guilty. Second Amendment shall not be infringed. This is a terrible bill, horrendous bill. Handy tried to run a very similar bill earlier in the legislative session. He abandoned that bill. My hope is that the Second Amendment community can really rally and make sure that this particular legislation dies quickly. Again, thank you so much for your time this evening, and we'll see you guys bright and early tomorrow up on the Hill.